Welcome to episode number 226 of AAA Weekly Knowledge Series. We are bringing to you today an issue which is coming to our mind, but the correct solution is not available. We know it very well that Section 238 capital A was introduced in IBC, where it was clarified that the Limitation Act is applicable in IBC proceedings before NCLT, NCL80, DRT, DR80. That is something which is very clear that it was inserted by way of an amendment in IBC pre 2026 amendment. So thereafter, it was many judgments that we have seen wherever Section 9, Section 7 actual applications were being filed, the defense was coming that it's a time bar. And in many cases, they actually succeeded because the debt was time barred. Therefore, Section 7 or Section 9 application was rejected. Because of the debt was time barred, the Supreme Court has come out with various judgments. So, for example, the judgment where the Supreme Court has held in the case of in case there is an acknowledgement of debt. So the Section 18 of the Limitation Act was invoked. So it was said that there was an acknowledgement of the debt. So therefore, the debt was considered to be renewed. So it was a kind of assumption or extension. Then there are judgments like the part payment was seen in between. And therefore, whenever a part payment is done, that also means that the limitation period is extended. That is what is provided in Section 19 of the Limitation Act. Similarly, the exclusion of litigation period as per Section 12, Section 13 and 14, because of different authorities, if the litigation is pending before an authority without having jurisdiction, that is what is covered in Section 12. And also in case it's a case of fraud, then Section 17 is applicable. And in case of any disability, the disability of the creditor, that is also provided under Section 6 and 9 of the Limitation Act. So that is all when an application is submitted under Section 7 or 9 for initiating CIRP, and this defense is actually very, very popular amongst all the corporate debtors. Earlier, there was no difficulty because even the resolution professional used to receive claims. He was not really bothered about the limitation part of it, whether the claim is barred by limitation or not. That was not being bothered because he was given a task, he was given a duty of collating the claim instead of verification. Now, the amendment. Now, first of all, Ankit, I think we have to just see what our audience is looking at. Our audience is looking at what has changed in IBC 2026 with regard to the verification of claims. So we need to understand what exactly is the claim and what is the difference between collating and verification of claim. And while verifying the claim, can RP look into the limitation aspects of the claim? So this is where, Ankit, you actually need to see what is the actual amendment in IBC 2026, how the role of the resolution professional is now, which is earlier it was for liquidator, but now it is for resolution professional. How has it been changed?
So let me first talk about pre-226 amendment. Pre-226 amendment, we had claim admission process at two stages. That was during CIRP and during liquidation. And the difference between that and today is that after this amendment, the claim admission process at the time of liquidation is done away with. So therefore, all those provisions also stand deleted. But we have a lot of jurisprudence which is available for this pre-2026 era. And there was a distinguishment made by my various courts, including the Honorable Apex Court, that the duties cast on the RP and the duties cast on the liquidator are different. So in Section 18 of IBC, which says duties of interim resolution professional, we have as part B of these duties, it says receive and collate all the claims submitted by the creditors to him pursuant to public announcement made under Section 13 and 15. This is what was written here. And in Section 35, which talks about powers of the liquidator, it said to verify claims of all the creditors. Now we have so many judgments where this had been distinguished, and it was said that the power to adjudicate and compute the value of claims is only there in the liquidation process. It is absent in the CRP process. Therefore, the job of the RP is only to look at the claim, verify it from the documents, or rather collate all the documents, see what all information or what all documents are given, and then just list out the claims. This was the duty of the RP. Now, in the Amendment Act that we have an explanation inserted to clause B of section 18. Explanation reads as under. It says, for the removal of doubts, it is hereby clarified that the interim resolution professional, while collating the claims, shall verify them and, if required, determine the value of such verified claims. So this determination of value, which was struck down by the courts, has been revived by the Parliament through this insertion of explanation. And as we know that through this explanation, when this amendment comes in, it is retrospectively applicable. So that means it's a clarification from the Parliament or from the legislature to the judiciary that no, this was the original intention, that the RP will also verify the claims. It is not that we wanted to distinguish the two. The language might be different.
But in this amendment, there is another line which has been added. In case we compare the earlier line, the liquidator was given a duty of verification of claim. But now the resolution professional is given a duty, and then this particular duty continues for liquidator also. And now the RP is liable, RP is duty bound to verify the claim and also determine the value of the claim. This determine the value of the claim is the word which is added. Earlier, it was not there in the liquidation process. So now, like in case we have to verify the claim as RP, and also we have to determine the value of the claim. That means it is a little more intensive. It is more responsibility. It is a little more intensive task. Now, we are coming back. We understand that determining the value of the claim and also verification of the claim. Now, in this regard, it is very important for us to read what is the definition of claim, which has got no change in IBC 2026. The definition of claim lies in section 3, subsection 6, and it says the claim means a right to payment. So the first threshold is a right to payment. First of all, the RP will verify whether there is a right to payment or not, whether or not such right is reduced to judgment, whether it is fixed, whether it is disputed, undisputed, it is legal, it is equitable, it is secured or unsecured. There should be a right to payment. So all these things, disputed, undisputed, legal, equitable, secured. So this is what is the definition of claim. Even if it is disputed, RP has to admit. Even if it is fixed or even it is not. The second thing it says, right to, the clause B says, right to remedy for breach of contract under any law for the time being in force. If such breach gives rise to a right to payment, again, there is a right to payment because of a breach. Whether or not such right is reduced to judgment, fixed, but here the words are added matured or unmatured. Matured or unmatured, disputed, undisputed, secured or unsecured. So in the first clause, it is the word legal or equitable. In the second, the legal and equitable word is removed, but the word matured or unmatured is added. Now, matured and unmatured means that if there is a loan and that there is an installment of the loan and that installment is not yet mature, still the claim has to be accepted. If it is matured or if it is not matured. If any installment is due after 3 years, but it is a claim, it has to be admitted. That is what it means. It is a right to remedy for a breach of contract. So if the claim says this, that the disputed, undisputed actually has to be admitted. Now the question is, if a resolution professional receives a claim and which is apparently time barred, so what he would do, he would actually seek information from the corporate debtor, whether it appears in their books of account as a liability or not. If it is appearing, then the RP can definitely apply a Supreme Court judgment and say admitted. Then in case there is any part payment received, then the RP can do that. But in case any of this is not found, or if the information is not given by the corporate debtor to the RP, then what the RP should do? What do you think, Ankit? Now I am giving a case. That situation is, the claim is received by the RP. Apparently, based on the documents, it is time barred. The information is not available from the corporate debtor. There is no acknowledgement which RP can see. There is no part payment which the RP can see. There is nothing which the claimant has submitted along. Even if the claimant can be further quizzed about for the certain information, but if there is no other information is available regarding any kind of litigation which is going on or any kind of acknowledgement, so if the claimant is also not able to give anything and RP is not getting any information from the CD, then can he say that I reject this claim because it is time barred?
Well, I don't think he can, because when we look at how the Limitation Act is interpreted by all the courts historically, we can come down to a judgment which is important, which is KP Khemka versus Haryana Industrial and Infrastructure Development Corporation. It's a 2024 judgment, and this 2024 judgment reinstates the distinction that has been present all along, and it says that under the Limitation Act, the liability survives, but the enforcement is barred. So this whole interpretation that Section 3 of the Limitation Act requires a court to dismiss a suit, appeal, or application filed after the prescribed limitation period, even where the limitation has not been pleaded as a defense. This section operates upon the legal proceeding, not ordinarily upon the underlying obligation. So this is a distinguishment, and this was so basically, it says after limitation expires, what all can happen? It says the debt or underlying obligation ordinarily continues to exist. It says the debtor does not automatically cease to owe the amount. But the creditor ordinarily loses the right to obtain a decree through a time-barred suit. The court must apply a limitation even if the defendant does not specifically raise it. Limitation should not be generally be described as making the original transaction void. And then we have this reinforced, and it says that again the same sentence was repeated, merely that limitation applicable to courts ordinarily merely bars the remedy and does not extinguish the debt. So if I want to read this judgment, or rather this interpretation of the Limitation Act, and I want to read it with Section 238A, which is inserted by the Parliament in IBC. 238A, again, only the limitation acts on the courts or the tribunals, because there is another judgment that this Limitation Act will not even apply to tribunals unless and until it is made part of the express provisions of the Act. Now, this 238A does not require the resolution professional to not accept the claim in case it is barred by limitation, and therefore the dismissal of the claim or evaluation of the claim will have to be on other grounds. So if I want to divide the possibilities, as you said, the CD is not cooperating. He's not giving me any details. So invariably, if I have enough documents on the table as an RP or as an IRP to say that this claim did exist based on those documents, I will have to perhaps admit it. While I say that, no, I am admitting it, I have observed that limitation, as per Limitation Act, this claim is barred by limitation in a court of law based on the documents you have given. However, I'm admitting it as I don't have any documents which are which say that this amount is in any way not payable by the CD to you. And if the RP can say, he can say that whenever any such documents come to his knowledge, which will require him to review his claim admission and reduce the quantum or reject the claim, then that liberty the RP will have to keep. Because if the CD is able to establish or give documents to say that this liability is not even due, then that will have to be shared by the IRP with the claimant for the claimant to give his answer, and then the RP will have to pass a reasoned communication, give the reasoned communication to the claimant saying that he gave this document, CD gave this document, and therefore this is the decision that the IRP is coming to.
No, I will add what Ankit is saying by just reading the Section 3 of the Limitation Act, and it is the bar of limitation, Section 3 of the Limitation Act, which is the almost preamble, and it says the subject to the provisions contained in Section 4 to Section 24, every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed, although limitation has not been set up as a defense. It is said that even if the other party is not using it as a defense, but it is the duty of the court to verify whether this particular application or whether this particular debt is time barred or not. If it is time barred, the court will dismiss. On the other hand, so this is one part that it is the obligation is on the court to dismiss all that. On the other part, the Property Company Limited versus Rohinton Daddy Mazda, it is a 2017 judgment of Honorable, it's a judgment of 7th January 2026 from Honorable Supreme Court, where the Supreme Court observed the provisions of the Act, Limitation Act 1963, would only apply to suits, applications, or appeals, as the case may be, which are made under any law to courts and not to those made before quasi-judicial bodies or tribunals, unless such quasi-judicial bodies or tribunals are specifically empowered in that regard. To cover this part, the IBC was included, so 230A capital A was added. So therefore, this limitation law is applicable to the tribunal also. Now, the only question is that it is only and only applicable to the tribunals. So the RP, so far, hardly there is any legal case which says that the resolution professional is also a quasi-judicial body. Not very clearly, although the IBBI says at times that the resolution professional is a quasi-judicial body. But looking into this judgment, this only can be, this limitation law, the provisions of this law would only apply to suits, the appeals, because before the resolution professional, there is no suit, there is no application, there is no appeal. The only thing is the application is for admission of a claim. And very recently, Honorable Supreme Court has said in one case, Ankit, what is that case? Do you have that case in front of you, or should I open? The very recent judgment of
Shankar.
Yes, Shankar.
So this is Shankar Khandelwal versus Omkara Asset Reconstruction Private Limited. It's a it's a judgment dated 29th of April 2026. And here the question of law was that whether the admission of a creditor's claim by the resolution professional during a CRP constitutes valid acknowledgement of debt under Section 18 of the Limitation Act, thereby granting a fresh period of limitation for instituting a new Section 7 IBC application. Now here in this judgment, I believe I can share that this was an NPA declared in 2016, and that's where, this claim was admitted by the RP. Those are the facts. And then finally, NCLAT decided on this matter, and the first ground was that the act lacks the intention that Section 18 demands. So it says that the verification or the claim was verified by the RP and it was not done with full attention by the RP.
Now, in the meantime, what exactly the Supreme Court says, like, you cannot take this as renewal. If the RP has admitted a claim and later on another application is filed under Section 7, so you cannot take it as a renewal because the RP had admitted a claim earlier. Because the the admission of a claim is an administrative task. It is not a judicial task. So that is what has happened. It will not be considered as adjudicated. Now, on another hand, in one of the IBBI order, where the IBBI has taken an action on an insolvency professional, dismissed that insolvency professional for 2 years, only because the RP admitted a claim which was earlier adjudicated by a court as time barred. Now, an application was filed by another creditor under Section 7 or 9, and that was rejected because the NCLT held that that particular claim is time barred. Another person filed an application and this claim again came before the RP. So RP did not notice, RP was not even informed whether this particular claim was time barred, earlier adjudicated by NCLT. I'm not sure whether it was informed. But in this case, the IBBI says that once a court has already held that this claim was time barred, that means nothing is due. There is no right to payment. So therefore, the RP should not have admitted that claim. So what I'm trying to say, if there is a sure shot case, if there is a clear case of Time Limitation Act applicability on a claim, RP should not accept it. If it is a very clear case, RP should write a communication to the claimant clearly saying that this is what my observation is and this is the clear-cut case of a time-barred claim. And then the other person can go to NCLT for adjudication. In case having full knowledge that this particular claim is time-barred and still the RP accepts that, I think that is a little risk. Otherwise, RP will not adjudicate. RP will not see acknowledgement, will part payment. RP will not say litigation pending. RP will not see anything, because that is something which is any court has to see. RP will only see what is apparent and very clear. If it is a clear case of complete time barred claim, then yes, RP should not accept that. So Ankit, we have touched this judgment also. We have also seen the IBBI order, which actually suspends an insolvency professional for 2 years. So in case it is a clear case of a time barred claim, RP cannot accept it, because in that case it can be considered as a kind of a conflict of interest also, or compromising his situation.
I think the RP is duty bound to make inquiries. I'm
Or
sure
yes.
that you're saying that when the RP writes back and says that this debt appears to be barred by limitation based on the documents that are provided, and at the same time the RP's continuous efforts to engage with the corporate debtor and get some information from them or from the books of accounts can also help. And of course, this judgment that we're talking about, based on which this resolution professional was there was a disciplinary action by IBBA on the resolution professional, is a case where the maybe where the NCLT's adjudication on that claim was not brought to the attention of the RP. Because what NCLT had done there was, NCLT had said in its order that since Limitation Act applies, this claim or this debt does not remain anymore. There were other ideas also which were added, which kind of gave the suggestion that NCLT was not convinced that the claim or the debt was actually there for them to initiate CRP against that company. So that's where I believe that somebody must have pointed that out to the NCLT at a future date, and that became a reason for this kind of an order. But yes, as I said, I understand that that based on the new explanation now that we have, the duties with respect to how to admit claims has enhanced, and therefore it becomes very, really important to communicate what the RP is thinking, why is he taking a decision, and also at all times do whatever is possible to collect all relevant information with respect to a claim before taking a decision. I believe at several times when we stop receiving any response from the corporate debtor, we give up, but and we leave the books of accounts unattended, or rather we don't see them for the purpose of kind of verifying claims. But I believe now it has become even more important to say that, okay, what do the books of accounts of the CD say? And if they don't talk about that debt, then kind of pointing it out, distinguishing it, trying to understand that why this debt is not in the books of accounts of the CD.
In fact, I would advise a 4-step test for the insolvency professionals acting as IRP or the RP, and as far as this limitation part is concerned. And the first would be that he should compute limitation. I mean, calculate the time to insolvency or liquidation commencement and see what is the time of limitation. The second step would be search records, search the financial statements and books of account of the corporate debtor, find out some kind of one-time settlements and the correspondences for acknowledgement. Third step would be identify defaults. Unless he has the date of default, it would be very difficult to apply limitation law. So the first is the compute limitation, then is the search records, and then find the date of default, and finally very clearly record his position. Very reasoned order for non-admission and very reasoned order for admission. Now, in case, I would say, do not reject on limitation as a reflex. Do not reject on limitation just on a reflex. And also, do not admit on the same manner. It has to be a very, very detailed communication, and it should be immediately, the effort should be made that it should be adjudicated, not by the RP, but by the court. But the issue must be raised by the RP so that a clear time-barred case is not incorrectly admitted by the RP, and the RP comes under the reasons of IBBI penalties. So that is what is the overall scenario which we actually can say. Although we are not finishing, we will explain further so that what exactly the position would be how the law has changed over the period. Because see, we have seen starting from 2016, Regulation 13.1 in fact was added, where it was saying the RP is to verify every claim as on insolvency commencement date within 7 days and maintain a list of creditors. Even at that time, while the code was saying to collate the claims, the Regulation 13 sub-regulation 1 was saying verify every claim. Then in July 2021, Regulation 13 sub-regulation 2 clause B said it extended to authorized representatives of members, partners and directors and guarantors. In November 2020, before that, the list of creditors filed on the board's electronic platform, a transparency and limitation measure. And so this is what has been the journey as far as this collation and verification is concerned. That is quite clear that the verification was earlier with the liquidator, and there was also an appeal. Like the heading of that section 42 was appeal, which is now deleted. IBC 2026 has deleted all this section 38, 40, 39, 40, 42. So it's all been deleted. So that means even that appeal is deleted in case there is any person aggrieved by the RP's verification of claim. He can only go to NCLT under section 60 subsection 5 as a general jurisdiction of IBC, because in section 60 subsection 5 it is also mentioned that the in case it is a dispute regarding claims, then the NCLT will have the jurisdiction. So coming to this, like what we are trying to say, there are few verbs that we would like to use. And the first verb that we can actually say is the collation. Now the collation, like in case we understand the meaning of the collation, is receiving, compiling, arranging. This is a ministerial act. No evaluation, not a decision. That's what this verb says. Now coming to verification. Verification is testing the claim against objective material. Objective material is the material which is available on record. Forms, documents, books, information utility, records. Evaluation of proof sufficiency, not resolution of contested rights. So even the verification is also not to provide a resolution for the contested rights. Verification is restricted to the objective material, available material, forms, documents, IU. It is restricted to that. Now the next is determination. Now in the determination of the value of the claim is also important. So that verb also can be explained. It says fixing quantum, including best estimate for contingent claims. Best estimate for the contingent claims, reviewable. Estimate attracts a margin of appreciation. Now, this is what is the meaning of this verb determination. Because we have seen collation word in the code, we have seen verification in the regulation, now in the code, and now we have seen the determination also in the code.
Regulation 14, just to be clear on determination, gives wide powers with respect to determinations. It's titled only determination of amount of claim.
So this, I think Ankit is trying to say the new regulation 14 of CIRP regulation, which talks about determination. Yes.
Determination of amount of claim is the heading, and then says where the amount claimed by a creditor is not precise due to any contingency or other reason, the interim resolution professional or the resolution professional, as the case may be, shall make the best estimate of the amount of claim based on the information available with him. That's what it says. And then it of course talks about the interim resolution professional or RP, as the case may be, shall revise the amounts of claim admitted, including estimates of claim made under sub-regulation 1, as soon as may be practical when he comes across additional information warranting such revision. That's why I was saying what I was sharing with you, that initially when the CD is not sharing information and limitation still kind of is coming up, maybe a call can be taken by the RP to admit the claim based on the information available on record, and when the information comes in with respect to any dispute, with respect of any other information that requires him to not or reverse that admission, then he can make that change.
No, it's actually good that the determination is completely defined in Regulation 14 of CIRP regulations. Like, see, let me continue the 6 verbs that is being used and the meanings of all the 6 verbs. I have already discussed collation, verification and determination. Now the other 2 verbs which are being used in the regulations and the code is the admission and rejection. 4th and 5th verbs are admission and rejection, formally carrying the claim into or declining to carry it into the list. Basically, the RP's job is to carry it on a list, prepare a list of creditors, creates no acknowledgement and no substantive right, because the Supreme Court has said in this case that even if the RP has admitted a claim, it does not create a acknowledgement. It does not become a substantive right. After that, in case somebody still can say that this was time barred. Now, these 5 verbs, and then the last is adjudication. Now, the adjudication that means authoritative determination of contested rights after notice, hearing, and evidence, binding until set aside. So the duty of the insolvency professional as IRP, RP, or as a liquidator is restricted to the first 5 verbs: collation, verification, determination, rejection, or admission. It is not up to adjudication. Adjudication should not be done in case it is a contested right. It is not to be performed by the insolvency professional. It is not something, it has to be adjudicated with after a hearing, after a notice and a contest. So this is where the difference is, like what is the duty? It is restricted to the first 5 verbs, and it should not trespass to the word adjudication. This is something, and this is Ankit quite clearly what I'm saying. So in case we see various other observations so far the courts have done, so the correct characterization of the claim, admission, or rejection is the administrative in character, decisional in form, consequential in effect. Now, it says that not quasi-judicial in the classical sense. It actually there are judicial judgment, because I don't want to take time, because there was some reference to in Swiss Ribbon also, ArcelorMittal also, COC of SR Steel also, Rainbow Paper also, but then I'm not going into those detailed paragraphs. I'm just discussing the kind of meaning of those observations. So the corporate debtor is not a party before the professional, and his decisions binds nobody. There is nobody who actually is coming and presenting their case. Like, see, in case we say that the RP has an adjudicatory power, so the RP will invite corporate debtor, on the other hand claimant, and RP will have a hearing. No, it's not required. It's not possible. So that's what is not. It is not the duty. Now the only thing is, but the duty to act fairly, that is attached. To act fairly is attached. That's what IBC said in that case where the insolvency professional was suspended, because it was a clear-cut case that already held by a court that it is time barred. So the court said that you actually have to act fairly. So in case I keep accepting all time barred claims, and then nobody is filing an appeal, and I actually distribute money to them, it is not fair. So the function acquired the incidents of an administrative decision affecting rights. If the administrative decision is affecting rights of other parties, then it should be challenged. It should be fair to others. The professional must consider material filed, avoid extraneous consideration, give reasons that engage with the claim, and communicate within the stipulated period. In case I held that claim with me, I do not take a decision, and I take a decision after some time. So it has to be fair. The other party should have a right to file an application before NCLT to get it adjudicated. When we see the constitutional reading, the consistent with the Swiss Ribbon and also the Article 14, the decision is a reasoned administrative proposal, subject to complete re-examination. Any construction treating it as final would confer adjudicatory power on a private professional by subordinate legislation without hearing evidence on merit or appeal. So this is what exactly the correct characterization of the task of the insolvency professional, that it is administrative in character, but it has to be fair, and ultimately it is not binding on anyone. It cannot impact the rights of other parties. So what is the anything that you want to add, Ankit, in this?
Nothing. Yes, I think we can conclude that although we have an example where there is a disciplinary action on an RP with respect to Limitation Act related matter, but I think we can distinguish that, one, based on the idea that it was pre-amendment, number one. Number two, we can say that yes, the recent judgment from the Apex Court in 2024 revalidates the idea that limitation and debt are different parts or different things. I think, but yes, it's important to review those claims which come with a limitation, and of course decide them based on all the 6 verbs that you talked about.
So I believe still 2-3 more things that I would like to say. One, that the insolvency professional should also see whether it is feasible or not for him to understand whether it is barred by limitation or not. That feasibility is also very important. Second is that he cannot actually cause delay only because he wanted to understand about the limitation part of it. Third is it is a moral hazard. It has to be very clear. It has to be ethical. Only because of the limitation issue, it should not actually come on his moral. And then the commercial reality has to be seen. The operational creditors with technically stale claims may be critical to the going concern objective. So with this, we are actually closing this episode 226. We are not able to send our WhatsApp messages to all our viewers. Do subscribe to AAA Insolvency YouTube channel so that the notification will come to you whenever a new video is released. But our time is fixed. Every Saturday at 11 a.m. our YouTube weekly episode is released. So we may not be able to send you the WhatsApp messages, and with the link, there is no need of a link. 11 a.m. YouTube channel called AAA Insolvency. You should subscribe so that you get the new notification. Thank you very much.
Thank you. Thank you.